Chet, let's turn to the board's role. So when a company enters M&A territory, whether it's as an acquirer or as a target, what are the core fiduciary duties directors need to understand, and where do you see the boards being most vulnerable in today's environment?
Yeah, so that's a good, so everybody here, in some capacities, and probably a board member, certainly understands as a board member, you have kind of two principal fiduciary duties, the duty of loyalty and the duty of care, right? The duty to act as a reasonable person would, act in good faith. And those duties exist in any M&A context, whether you're on the buy side or the sell side. So those continue. And they're slightly enhanced, I would say, in that the expectations are a little bit higher when you're doing an M&A transaction. And primarily, particularly if you look on the sell side, that's where you see them becoming more enhanced and potentially even enhanced to the extent that those duties shift not only from just acting as a reasonable person would, but also getting the best value for the bank. Because if you're in if you're selling your bank, I say bank because I represent a lot of financial institutions, but your company. But if you're selling your company and you're selling it for cash, so you're selling control, then there's some case law that basically implies these enhanced duties called the Revlon case, which means your duty is to maximize the value to those shareholders. And so it's not just the basic duty, but it's enhanced. And in doing that, that means a lot more, it's more important, and this is true regardless, and certainly on the sell side, is to manage the process, document the process of what you're doing, how you're involved, even though, management may be doing a lot of the due diligence, but you have to make sure that you're asking the right questions, following up, getting reports, and not just relying on basic summary due diligence reports, but really dig a little bit deeper, ask the tough questions, because at the end of the day, those minutes that are being drafted in those board minutes, in those board meetings, are really going to be your best protection if there is any kind of litigation. Now, litigation's rare, and we might talk about that a little bit later, but I think you have to have an eye towards making sure you're documenting this process and that you're going through a thorough process. And so again, on the sell side, the other issue that comes up is also maintaining the independence, because inevitably, typically on the sell side, you've got certain conflicts of interest that might arise because you've got an executive that's getting some type of compensation from the buying company, and you need to make sure you're managing that, or if you've got principal shareholders or other assets are being sold outside, you've got to really identify those conflicts and manage those as well. As you flip to the buy side, the duties aren't quite as high. You don't have this notion of these heightened duties under Revlon, but it's still important to go through and pay attention to diligence, making sure you're asking the right questions, identifying what are the key risks here, how are we managing those risks, how are we going to mitigate those risks, and really asking those questions and being involved in that process. Because at the end of the day, it is really about risk management, because the one thing I know from any acquisition, there's always going to be a surprise at the end, and you're just hoping that, and there'll be multiple surprises probably, you're hoping that the good surprises outweigh the bad surprises, but you're also planning for that kind of worst case situation, or at least the surprises that come up after the deal closes.
And one thing I'm thinking about is how fast these deals move, and you're trying to cover all the bases, and you're getting a zillion emails every day.
Well, and that's a good point, because speed does kill deals, but also if it's moving too quickly, something's going to get overlooked. So you've got to be careful about that process. And part of it is the optics of the process that you're trying to go through. Because if you sign up a deal in 10 days and it's a $100 million deal, well, that's probably not a reasonable process, right? So, but be careful in the sense, and particularly as an outside director, that you feel like you've gotten the information and you're getting that before you're putting that to a vote, because making a rush decision is a real risk for a fiduciary, and just in having that process organized and having somebody that's managing it, part of it's getting good advisors and getting good people that are helping you on your third parties doing your due diligence and making sure you can rely on those advisors. Because as a board member, you can't keep track of it all, but ultimately you need to be cognizant that it's going right and you don't feel like you're getting rushed. If somebody sends you an agreement the day before, a 50-page agreement or a 100-page agreement, and says you need to look at this because we're voting on it tomorrow, you need to probably say, timeout. That's not right. I can't reasonably do that. I mean, and so be careful about it, and but knowing that every deal is you're going to feel rushed. That's part of the process in any deal.
So a bit of a follow-up for our other two panelists, if you want to chip in on this. So Mark or Matt, from your vantage points, where do you see boards coming, to the table sort of underprepared on governance?
So a lot of it is, and you may have already kind of touched on this, but there's a lot of focus on getting the deal done, and there's not a lot of focus on the consequences of what is unknown or unresolved ahead of that. And I'm being very general, but if I put my comp hat on, it's really related to what pieces are left over from the previous company, what is going to leave the new executive team undermotivated or not as engaged because they didn't come out of the deal exactly the way they thought it would be. So these are kind of unintended consequences, I guess.
One that I see is, and it kind of Chet touches on the theme that you're talking about a little bit of pace and being prepared, is helping test the timing of critical steps into the transaction, and the right balance, between pace and risk. And example that I have from a recent deal that we were supporting that involved a acquiring company pulling in a few thousand employees, and there was a very short sign to close window, and the management team's preference was to onboard all employees, transition employer on day one. There wasn't anything in the transaction construct that mandated that, but that was their preference, and the window was really small, and they're at risk of messing up comp and bin for a few thousand employees, which of course you don't want to do coming out of the gate as the new owner. So helping test things like that of the critical steps and the timing and the trade-off between pace and risk, I think is important.
Okay, good. Thank you. Thank you for the additional color. And Chet, when you mentioned getting the 50 or 100 or 300-page document, I used to feel like I needed to understand the entire thing, and I'm not an attorney. And so I don't think any of us should be shy about saying, hey, I need a summary of this, especially now that we have AI. But I need a summary of this, and I need our outside counsel to be in the meeting with us to take us through this and explain the nuances of these, very important sentences with very important words in them that all have all sorts of background, law and regulation and case law and all sorts of interpretation that a non-lawyer may not fully appreciate. So I do think in terms of, and that leads me to kind of my next question, which is it's for Chet, expanding a little bit on documenting, and you touched on this in your comments, but when we talk about documenting our deliberations and decisions throughout a deal process, there's a wide spectrum. Some directors like to take notes. Some directors like to have the general counsel take minutes. Outside counsel sometimes is taking minutes. Can you just talk about the whole spectrum and how we ought to think about that side of it?
And some people like to record them on Otter or some other, so there's which is legally I would tell you that's a bad idea because you don't want that out there at all. And in minutes of these meetings and documenting the record are important because, as I mentioned, that's going to be the sole record of what's going to judge you. First thing is going to judge you. Yeah, there could, if something goes bad, and that's really, you're thinking about that kind of protection as you think about what minutes really do. And there's a fine balance between them being too brief and too and too inclusive. So it's finding that kind of magic mix where they really talk. If there are certain issues that are important, then there's a focus and show that there was a discussion, that you looked at certain reports. And so maybe instead of 2 sentences about the board looked at it and discussed it, you would say, we also analyzed these, and several board members asked questions specifically about X, Y, and Z, and what are the risks, and we identified it. And so you've got 4 or 5 sentences on that discussion topic. And so without going too overboard, I think is the key, is again, thinking about it and having outside counsel or somebody that really understands that to be able to go through those minutes at the end of those meetings, and is probably good advice, particularly if you're in a public company or something that's more, you kind of got a higher fiduciary risk kind of transaction.
All right, thank you. I think good discussion on this. Lots for us to remember the next time we're in an M&A deal on documentation.